the police that he test fired that gun at a wooded area behind a restaurant where he worked. The police went to that scene and they recovered a .25 caliber shell casing at the test fire scene. Police and the FBI compared the markings on that .25 caliber round found at the test fire scene to the to the casing found at the scene where Mr. Kinzer was found, determined that those markings were a match. The examination of both casings led the FBI lab to conclude that they were fired from the same .25 caliber pistol, the gun Mr. O'Connell sold to the defendant. During the initial investigation with the police, the defendant denied purchasing a gun from Mr. O'Connell. He denied owning a .25 caliber pistol. During the second trial, the defendant testified he admitted to purchasing a .25 caliber pistol from Mr. O'Connell, but he claimed to have purchased it after Mr. Kinzer went missing. The conclusion that a .25 caliber jacketed bullet was found in and among the remains of Mr. Kisner has not been disputed. The conclusion by the FBI that the .25 caliber casing found under the body and the casing found at the test fire scene had the same distinguishing marks have not been disputed. The extensive forensic evidence introduced by the lawyers for the Commonwealth at the motion for new trial establishes and supports the FBI's conclusion some 40 years ago that the entry hole in the skull of Mr. Kinzer was consistent with a .25 caliber round, consistent with a .25 caliber round found with among the remains. Given the background of this case and the decision of Judge Grind granting a new trial, it is not an easy decision for the Commonwealth to decide how best to proceed, and it's been one that our office has examined, thought upon, and spent a great deal of time making. After 44 years, some of the Commonwealth witnesses are dead. Some of our evidence is no longer available. Witnesses' memories have faded, and the realities of a new trial 44 years later is made complicated by the passage of time. Nevertheless, given the work that's been done by our legal team and the forensic experts, I conclude clearly that Mr. Kinzer was killed by a .25 caliber pistol. That evidence was good 40 years ago, and it's good today. Nevertheless, the facts remain that trying a case 44 years later will be extremely difficult, and the probabilities of success are not what they would have been 44 years ago. We have made the decision to forego further prosecution in this manner. Some of the factors that weighed on my decision are the fact that the defendant was 19 at the time of the death of Mr. Kinzer, the murder of Thomas Kinzer, and that he has had 44 years of confinement with no reported issues that lead one to conclude that he does not pose a threat to the public going forward. It's my conclusion that the interests of justice, the interests of the Commonwealth, the interests of the citizens of Center County, they are served by this 44-year prison sentence and not served by going forward further. The action our office is taking today does not reflect on the quality of the State College Police Department investigation. It was then and is now a compelling case of forensic evidence and a thorough investigation. Given the implication of Judge Grind's opinion, the real-life difficulties of trying this case now, and that 44 years is a sufficient sentence for a murder committed when someone was 19 years old, we will today file a request that the case be dismissed. It is not a decision that has been made lightly. Nevertheless, everything that has occurred thus far leads me to believe that it is a just decision. If you have any questions, we'd be happy to address them now.
How long have you been thinking about this? How difficult for you personally is this? Or is it something after Judge Braun's decision late August that you started thinking about more seriously?
This has been on my mind for the last 2 years. When we first were asked to look at this case, I had no idea what the forensic evidence in the investigation supported. 2 years later, I am comfortable and confident that I understand the evidence. I'm also cognizant of the realities of what a retrial will look like, and that this is the just decision at this point in time.
Was it difficult to explain? You have the police taking it to folks in law enforcement and others who still feel Mr. Vedam is guilty man to explain them what you're doing?
Yeah, this was not made in the dark, and it was not made without input from the family. I'll let Chief Gardner make a statement here in a second. We've spoken to the family, and they appreciated the fact that they were brought into that decision making. I'm not going to say they understood it. And as for law enforcement, at least for the State College Police Department, they have been part of this decision making process from day one. I'll let Chief Gardner address your question.
What was your question again, Gary?
Your thoughts on this? It's certainly many in law enforcement still think Mr. Vedam is a guilty man.
Right, and I don't think this decision takes away those beliefs in a lot of circles. I will say none of us were around when this crime was committed. As the DA said, I thoroughly believe that the investigation that was conducted way back when was a good investigation. It was a thorough investigation. It was a complete investigation that pointed to Mr. Vedam. But for the reasons stated by the district attorney, I'm in complete agreement with his decision to do this, because I too agree with 44 years is a long time, okay? And that might be easy for me to say because I'm not a family member or things like that, but I just know the difficulties of trying to retry this case right now would be almost insurmountable.
Bernie?
Thank you, Chief.
Yep. Thank you, sir. Vedam's legal has GoPol or any others been before, or did you talk to them, what you're going to do?
They know that we will be walking over a request for an order to the courthouse at 1 o'clock.
Do you know what kind of timeline it is now before he's released? Or?
No, you'd have to direct those questions to defense. This is a matter that will be assigned to a judge this afternoon, and I'm presuming that we'll be hearing from a judge later today in all likelihood.
Just to make sure I understood correctly, with Kinzer's family, you said that they were brought into it, you had discussed it with them. I believe you said that you said that you weren't sure that they understood or agreed. So I guess the question at the end of this is, can you just, how did the family?
Well, what I would say is, I'd say a couple of things. I don't want to speak for a family member who's lost their brother, someone that they love. And I don't want to speak for how they feel. I can tell you that just talking about, I could tell that it brings forward pain and injury and harm that has laid dormant for a very long time. And they've been advised when this first broke a couple of years ago, they were advised, and before I stood up in front of you, the relevant person, I think the most relevant person that needed to understand what was happening was spoken with too. How they feel about that, I'm certain that they're not going to tell you. They're going to keep their feelings to themselves, but they certainly, I would not do anything without making the people who should know.
After his release, is there any type of court supervision, probation, anything like that? Or
No, sir. No.
It sounds like his record as an inmate played into your decision that he's, by all accounts, been a moral end, if you can say that.
There's no doubt if there were concerns about public safety, this would not have occurred. I've said publicly, had this been a request for a commutation of a sentence, I would have joined in that request. We're certainly not objected to it. This is not something that I'm enjoying or liking doing. Let's just make that clear. It's something that I feel the facts compel us to do today.
Just as a point of clarity, you said you spoke to a family member. It was a sibling of Kinzer's?
I really, I'll confirm I spoke to a sibling, yes. And beyond that, I really don't feel it's, I feel I'm not at liberty to speak for them, nor would I do so.
We realize you're on the criminal side. Any thoughts on possible civil case resulting?
Again, yeah, you're right. I have my job, and I've done my job based on what I believe is fair, right, and just. As to any other proceedings and effects of this, that really is not in my lane. If there aren't any other questions, that's really all I have for today. Thank you.
Thank you.
Yeah, let's do that. That'd be great. If you look at the null process, there's an Exhibit A signed by defense counsel, so they knew what was going. There was certain things that were agreed to.